Good morning to all the viewers. Today at our International Economic Forum of Commerce Industry, we are going to have another discussions on the Uncitral laws on international mediations. It is very important for us to know the basic, the features, the steps involved in the mediation process. Since IEFCI provides international mediation, and I'm also a trained international mediator, and we do offer the international mediation, across the borders. So, what are the basic ancestral, laws that are involved in the international mediation process? First of all, we have to know that, apart from the flexibility that mediation offers, the convenience, to settle out the agreements and the disputes. What are the main features of mediation? Mediation is an efficient and cost-effective dispute settlement mechanism. It allows parties to prevent or settle a dispute, taking their interests into account and avoiding a win or lose outcome. Mediation can use for solving wide range of disputes. It can use results in significant benefits such as facilitating the administration of international transactions by parties and reducing the instances where a dispute leads to termination of a commercial relationship. Non-adjudicatory process. Mediation is not a formal and in contrast to any adjudicative proceeding. It does not rely on complex rules of forms and procedure. Indeed, the matter in which a mediation process unfolds is not legally predetermined. In successful mediation, the parties frequently shift from one adversarial party against the other to a solution oriented, both parties agree against the problem mindset. Even if the parties do not reach a settlement agreement, the process can still allow them to gain a better understanding of the issues at stake and overcome the unrealistic expectations. Mediation is a very flexible process which allows the parties to tailor it as they wish, taking into account their needs as well as the circumstances of the case. As a result, the mediation is usually less time and resource consuming than adjudication. The parties focus on their underlying concerns and interests. They can resolve potential misunderstandings and develop the basis for a long term business relationship. Voluntarily process based on a party autonomy. Mediation relies on a party autonomy. Indeed, the party retains the full control of their participations in mediation. Unless the mandatory requirement apply under a relevant source of law, the parties are usually free to agree on the mediator, agree on the conduct of the mediation process, determine the scope of issues to be submitted to the mediation, develop their own solutions, solve their dispute holistically or agree to party solutions, and terminate the mediation at any time. The following chart provides an overview, of the mediation process. There is a basic, chart that we follow. The first is a pre-dispute contractual negotiation, then is invitation to mediation, then, the party negotiates on the mediation process, then the discussions on the consent with the mediator begins. Then the mediation process is there, like organizational discussions, opening statement by parties on the issues, the communications thereon, opinion development, drafting of settlement agreements, the possible duration of mediations, the single day or the multiple days, the conduct of mediations and sessions, private message. So these are the certain steps that we have to follow, and then is the enforcement process if necessary and available. That is relating to the settlement agreement. So basically, once this framework is followed, people they come up to the settlement agreement if both parties are willing to conclude the mediation process. Now, what is the legal framework in Singapore? Singapore Convention on Mediation. The United Nations Convention or International Settlement Agreement resulting from the mediation, that is basically known as Singapore Convention on Mediation, was adopted by the UN General Assembly on 20th December 2018. Applies to the international settlement agreement resulting from the mediations concluded by parties to resolve a commercial dispute. As defined in the convention, it provides a uniform and efficient framework for enforcement of the international settlement agreement resulting from mediation and for allowing the parties to invoke such agreement. It ensures that a settlement reached by the parties becomes binding and enforceable in accordance with a simplified, streamlined process. Now, the mediation laws. Mediation laws, such as those modeled by the Uncitral model laws on international commercial mediation and international settlement agreement resulting from mediation, usually define mediation as a process where parties are assisted by a third person or a person in their attempts to negotiate and reach an amicable settlement of their dispute. The mediator is there to assist the parties in their communications so they can find a solution and has no authority to impose a solution to the party. Now there are mediation rules. The parties may agree to use a set of mediation rules. Such rules usually determine the procedural frameworks of mediation. For example, the Uncitral mediation rules are a set of procedural rules that can use without an institution administering the mediations, and the parties are free to modify and adapt as they wish. Now, there are a list of matters for possible consideration in organizing a mediation. Commencement of mediation, various bases, agreement of the parties, invitation to mediation, date of commencement of mediation, institutional support. Select an appointment of a mediator. How to select and appoint a mediator. Availability, skills and backgrounds. Ethical requirements. Now, preparatory steps. The term of reference, fees and other costs, the administrative assistance, the parties' attendance and representation, addressing the confidentialities, determining the location and timings of the mediation, agreeing on the language of mediation. The next is the conduct of mediation, role of mediator, initial consultation, submission and supporting documents, mediation sessions and active negotiation, settlement agreement, settlement proposal, drawing up the settlement agreement and enforceability, the termination of mediation. Now, how the mediation actually commences? Mediation can be used successfully at different stage of disputes, either before or during an arbitral, judicial, or other dispute resolution proceeding. Mediation can be carried out based on the agreement between the parties, whether the reaches before or after dispute has arisen. Mediation often represent the last possible attempt to find a solution to settle a dispute before formal proceedings are initiated or after they are concluded. Mediation also can be carried out based on the obligations established by an international instrument or by law or by directions and suggestions of court, arbitral tribunal, or competent government authority. Then there is agreement of parties. There is a pre-dispute agreement. It is advisable that the parties to include in their contract and a mediation clause. Such a clause usually provides that the parties will seek to solve any dispute under the contract through mediation. It is going to be a fair process, right? And then there is an agreement that yes, there is an existing dispute. Then there is an invitation to mediation. The parties that wishes to commence mediation usually send an invitation to mediate to the other parties. In the beginning, we brief the outline, the legal issues are discussed. We identify identification of the basis for mediation, such as whether an invitation is made under the agreement or on a different basis. Then we come up to the next step is the date of the commencement of mediation. Then whether we are taking an institutional mediation or not. If an institution we have approached, then the institution is going to hire their mediators. Then the availability, nature and the cost of the institutional support. For example, every international mediation or institutional mediation forum, they have their own rules, they have their own fees, right? So that is to be followed out and that is to be known. Then the next process is the selection and appointment of mediator. If you have approached an institution, the institution generally appoints a single mediator in order to allow for speedy and lesser expensive process. Now, the mediator is generally familiar to the language, culture, law, and the trade, and the kind of dispute that he is going to deal with or she is going to deal with. Now, availability, skills, and backgrounds. While selecting a mediator, we see their availability, their experience, their trainings, whether they are internationally accredited mediators, as we have international mediators who are accredited by CMC in London, in Singapore, Netherlands, who are entitled to handle the international mediation disputes across the globe. Within India, we do have over 40 hours mandatory training for the mediators. So there are various training and experiences that are to be completed that we will certainly discuss in our next series on international mediations and the career aspects relating to it, in which we are going to explain on how the experience and the training is to be acquired. Next step after appointing the mediator is the ethical requirement that he should be just, independent, he should be fair, he should not be biased. Then there are preparatory steps like the fees and other costs that are involved in the mediation process that we have to see. And then we have to deposit this amount to the mediation forum. The institution mediation forum has their own requisite cost for appointing, the mediators, the infrastructures of providing, facilitating the mediation dispute. Now we come up to the administrative expense. Definitely there are parties who are there, so we have to provide the administrative expenses. The parties' attendance and representation is must. If this is an offline mediation, both the parties will come up to the place. Supposing Delhi is the place, they will come. In case of any international dispute, if Malaysia is the seat, then in Malaysia both the parties will be there. If this is online dispute, through online mode, both the parties can sit and mediate the whatever dispute is existing there. Then confidentiality is to be discussed, that yes, it is a confidential measure. This is not going to be disclosed to a third party, and this is not going to be, this is going to preserve it within the boundaries of the mediation. So these are the confidentialities that are to be disclosed. Admissibility of evidence in other proceedings, determining the location and timings of mediations. We have to determine the timings and the locations of the mediation as well. Then the conduct of the mediator, the role of the mediator is he's going to be neutral. He's going to create a safe and neutral and supportive atmosphere, right? He's going to facilitate the mediation process. Initially, he will just take the consultations from both the parties. First, he will invite one party. The first party will explain, and then the second party will come. They will explain. Then there can be some supporting documents and evidences to support the dispute, the history of the case, what the issue is, what actually the party is seeking to in the mediation. So these exchanges can happen. Then mediation session and active negotiation. This is a process where firstly the mediator will speak to one party, then the other party will discuss the outcomes from one party, discuss the outcomes from the second parties, then will convey the outcome of one party to the second party only with the consent of the parties. When the parties are giving consent that yes, you can disclose this idea, that this is what we expect out of mediation, then the mediator can give the consent to explain it to the other party. So this is the mediation process. Then is the settlement agreement. Settlement proposal then is given by the mediator while listening to both the parties, right? If both the parties are agreeing to it, then they will prepare a settlement agreement depending on the applicable laws. The mediators, if so required, assist the parties in preparing the settlement agreement. For example, by providing a summary of agreed terms. Usually, settlement agreements are in writing. It is advisable by parties to check how these requirements can be satisfied. It is in sign and it is signed by the mediator. Enforceability. Generally, the parties comply the voluntary with obligations set forth in the settlement agreement. Nevertheless, the parties should consider any requirement as to form, including the language requirement, content, filing the registering or delivering of the settlement agreement set forth by the applicable mediation law, the relevant laws that place in enforcement and applicable mediation rules. Then is the termination of mediations. In some unusual circumstances, if we see the payment is not full, or there is unfairness in there, or there is any legal procedure that is not being followed, then with due consultation it can be terminated as well. It should be very clear, it should be unambiguous, recorded, as it may constitute the starting point of subsequent procedure, or it may